Okay, great. So welcome everyone to yet another fantastic panel from Managed Privacy Canada's Practical Privacy Insights series. Today is going to be just chock full of practical stuff. So stay tuned, stay on the edge of your seats because you don't want to miss today's discussion. We are graciously hosted by our, sister and partner and supporter, Knowledge Flow Cyber Safety Foundation, an organization whose lifelong mission is to educate children, youth, and vulnerable individuals on the safe use of the internet. Just quickly, some housekeeping items. This presentation will be recorded, and we have been told so by Zoom, and we had to consent. To respect your privacy, though, other than the panelists, we encourage you to turn your cameras off if you don't want to be captured. But you can always ask a question through the chat feature, and we would also encourage you to turn off your microphones so we can avoid any background noise disturbances. But if you would like to ask a question with your microphone, turn it on when you would like to ask the question. So just before I introduce our fantastic panelists and friends, excuse me, I want to remind you to enjoy, participate, engage with us, ask us lots of questions because it'll make it even more fun than we planned it. So introducing the panelists, Debbie Reynolds. She is a great presence on LinkedIn. She's a global data privacy and protection expert, a speaker, an author, an educator, and a prolific podcaster. She produces the most fantastic tidbits and podcasts at the intersection of law and technology, and how this impacts the privacy space. She's joining us from Chicago, our neighbor in the USA. Welcome. And I have Vanessa Henry, who is a dear friend. We've worked together many, many years ago, and we still are. She is now a data governance and emerging tech lawyer at Fasken Martineau. She's joining us from Montreal, the lovely city in Quebec. I have so many accolades to tell you about Vanessa. She's also a fantastic speaker, and she writes a lot, interprets a law. Great commentary, and she's also an instructor, more like myself and Claudio, at a university in Florida, where she teaches on cybersecurity and privacy and tech. So fantastic to have you here, Vanessa. Welcome. And then I have Peter Barbosa, and Peter is our neighbor here in Toronto, Ontario. He is the co-founder and CEO of Opsware Data, which is in the privacy technology space. And he has kind of looked at how privacy technology can impact our space with a lot of experience from TELUS and other great sources, and has created this company just much like Managed Privacy during the pandemic. We're thriving. So this is great to have you. And then my co-partner, Claudio Popa, who is a speaker and author of many books. He's a cybersecurity expert. He is called on all kinds of radio and TV talks and interprets all kinds of cybersecurity events. He is also a privacy professional and the founder of the Knowledge Flow Cyber Safety Foundation. So I hope that was like a deep breath. As for me, I'm your moderator today on the panel. I'm the co-founder of Managed Privacy Canada and the author of Privacy Management, the Digital Enterprise Certificate at University of Toronto School of Continuing Studies, and a member of the Knowledge Flow Foundation. So with that, long or short presentation introduction, let's go through the agenda. How did we get here? That was going to be our first topic. We kind of estimated 10 minutes, but we're going to go where the panel takes us. What do these acts mean? The GLBA and the Quebec Bill 64 that's coming into force in September. And where do privacy and security intersect in these two laws? But let's just have a reminder where we intersect. Then we're going to explore what does it mean for your organization. If you are anywhere in North America, you have to pay attention because the space is changing. There's a huge push from cybersecurity from the United States to strengthen the maturity of risk management in organizations, cybersecurity wise as well. And then we'll go to some conclusions and discussions, but don't forget, you can ask questions anytime. All right, so let's start with how did we get here? So I have a few visuals here. We're looking at the current US proposed cybersecurity law by the Biden administration. We're looking at an upgrade into the PCI data security standard. That's for merchants and credit card holders, organizations, and how the security safeguards have evolved. They've gone up a notch. Then we're looking at the Gramm-Leach-Bliley Act, and I put that image on purpose to properly read the title of it. And then of course, our own Quebec Bill 64. So I'm gonna ask Claudio to kick us off on the cybersecurity side.
Thank you for that. I think the theme for me for today is the devil is in the details. We're seeing a ton of new awareness on the part of regulators, on the part of government agencies, on the part of businesses even. We see a lot of awareness of the need to modernize legislation. We get that. We see that there's a need for documentation, which we call administrative security. There's a need for adequate cybersecurity controls, which we call operational security. There's an additional and very much present need for monitoring and real-time detection and correction and all that stuff, which of course are the IT controls. There's a need for all of these things to be juggled by companies of all sizes. And that need was determined organically. We evolved to the current mindset that has basically been screaming for the past 20 years, hey, you know what? You need to be able to, in order for you to be able to monitor, to tell people for sure if you haven't had a data breach, you have to at least have controls in place that monitor your security posture. And this is where the legislation is going. This is where we see PCI 4.0, like you said, where it's going. This is what we are seeing Quebec's new Bill 64 going. And this is where we're seeing the data protection rule from the GLBA, the safeguards rule. The fact is, we're seeing a lot of headlines, right? We're seeing these titles. You need to have a whole checklist. Have you designated an individual in charge? Have you got an incident management program? Have you got periodic risk assessments? Have you got a privacy impact assessment, et cetera? The big question for me, and as you correctly pointed out, from my cybersecurity, from my information security perch, is how are these things tied to actual security controls, and how is the effectiveness of those controls determined so that they can be trustworthy enough to be able to support those privacy safeguards. It's fantastic that legislation is going to soon have the teeth to enforce privacy safeguards, but those necessarily need to tie directly and irreversibly into security controls that are constantly monitored and tested, implemented properly, and so forth. And the second thing, as my secondary point today, is exceptions. What kind of exceptions are we looking for? The kinds of things that worry me are the verbiage around how, you know, we need to exempt certain organizations under that manage the information of fewer than 5,000
So I want to stop
subjects.
you there because that is lovely. And I was kind of parking it for the end. So hold that thought. Mm-hmm. I want to ask Vanessa to come in because Vanessa has been working at the intersection of cybersecurity and law for quite some time. And I want to see your perspective on how did we get here?
Um, I think it's, I think Bill, and the real name being now Bill 25, is definitely a step in the direction of cybersecurity. But I think very often people forget that personal data is just part of the data of an organization. So I like to take a step back because some principles are applicable. We didn't just get there, like they've been there for as long as businesses have existed, right? So a business, for example, as corporate asset, and directors and officers have always had the responsibility of protecting these assets because they need to act in the best interest of the business. In certain part of the United States, it's a very narrow conception of this, where it's the interest of the shareholders. In Canada, we consider that the interest of the business includes the interest of society at large, and does include the human rights, not only of the shareholder, but those includes the human rights of the users, of the employees, and the likes. So starting from this principle, let's pretend the data were actually buildings. Would you let them in the street, unmanaged, uninsured, with the doors wide open, and just say like, it's a free for all and use it whatever, and it's okay if it's fall apart, so I don't really care about it? Definitely we wouldn't do that. And now that may seem like a gross example, but in today's age, for many businesses, their main corporate assets are data. So if you look at social network, for example, they're in the top company in terms of valuation, but they barely own buildings. So definitely the data have replaced buildings for some of these companies. So that responsibility to protect the corporate asset has moved from the building to the data assets. Now, personal information is one part of it. The reason why we have a law for it is because it is the duty of the government to protect the rights and freedom of individuals. That doesn't mean that the other type of data assets shouldn't be protected, but the government doesn't very care so much about protecting the economic rights of the businesses, because there should be a natural willingness to do so, because it goes without saying that you want your business to be successful. So these two different type of law, about the human rights and about the economic rights, which come from intellectual property coming together, is what is the legal foundation for cybersecurity. The issue is that I think it took some time for people to make the bridge between this is what I have to do and this is what cybersecurity is, and they come together. Now, today, that means that we have board of directors that are at risk of being negligent. And if they look for the information that they get shows that they're negligent. So now they need to act upon it, and they need to put the budget. So some companies, unfortunately, are choosing not to look for the information because they think that will protect them from being negligent. And that's not the case, because not getting the information is also negligent behavior. You're not going to be protected by the law if you just go like this trying to manage your business, right? So,
yeah, I didn't know. Sorry.
So cybersecurity isn't new. It's not a new thing, but I think the awareness of it is new. And you have country like in the UK where they're starting to talk about having board of director. For them, it will be mandatory to have somebody that actually understands cybersecurity.
And the SEC is just starting to do the same. So, to the naysayers that, I like this discussion between the Europeans and the UK and the United States when they say, well, there's not a federal law in the United States for privacy. But United States is so strong in cybersecurity, not just law, but the way they're enforcing and the way they're going at it, from the GLBA Act, from the SEC. We are seeing actually that they are going at the board of directors, just like the UK, and they're saying, you know what, you don't have to have someone competent. You have to tell us, disclose how competent the directors are on the board. So from that perspective, I want to kind of flip it over to Peter. Peter has just come back from the IAPP conference in Washington, and he's been talking to people there and clients and potential clients. What is the buzz there, Peter?
Yeah, good question. So it was an exciting event. First of all, was really, really happy to go. Some interesting keynote speakers, right? You had the head of FTC there, Lena Khan was there. Tim Cook spoke as well. A lot of controversy around that and what he was saying. But really it seems like there's a lot of exciting momentum happening in the US, kind of state by state. Certainly since it was in DC, a lot of lobbyists were attending the event. And certainly kind of, pushing and advocating on what a federal privacy law could look like, or what they like to see it look like. But I think, you know, more or less the industry, from what I'm hearing down there, and a lot of consultants and lawyers, was really, you know, from something more kind of comprehensive, more federally, is pretty still far off. I think a lot of folks still want to see more CCPA-like privacy laws introduced. I know there were some amendments to, I believe, the Virginia, the new Virginia privacy law, more recently introduced, that kind of really removed a lot of the teeth it had prior when it was first introduced. So that was kind of a bit of a step back, but, you know, what I'd like to see personally is a lot more, you know, it'd be nice to see some states like New York or Illinois come alive with some type of CCPA like privacy law to really kind of get the momentum going. Because I think in the US, what you need a few kind of heavy states or big populated states to really kind of choose these laws for everyone else to follow.
But there's a lot of other stuff happening, like the cybersecurity law, the New York, very discussed Data Security Act. So there's so much going behind the scenes. And this is where I think security is such a great bed for pushing the controls, the maturity, the boundaries to say, but security is actually acting on behalf of protecting personal information as well. So I kind of want to go to our next point, which is a very busy slide, but I did it on purpose so that our participants can take something away of interest. Where do privacy and security interests intersect, right? So I am not sure what happened with Debbie. She seems to have has a bit of a problem. I hope she's coming back. But we can all comment on this. I'm going to just
Debbie's there.
I'm here.
She was
there
just,
you are.
she was just muted. She was off
Debbie,
your screen.
I'm really sorry. I wanted to pass this to you to kind of take us through what is new and why are we here?
Yeah. So the thing that is new with the Gramm-Leach-Bliley Act and some of the things that you're talking about that are heating up on the cybersecurity side is that either in terms of trying to outline for organizations what they need to do to protect data, and for Gramm-Leach-Bliley in particular, the new surprising thing that's happening that organizations need to wake up to, first of all, is expanding the definition of what they consider like financial institutions. So I think you add on the slide in terms of adding people who are finders, like lead generators, mortgage brokers. I think they even have tax preparers at some point in terms of financial organizations. So a lot of these organizations had not, up to this point, been subject to GLBA in the way that it was defined. So that's kind of one thing. And then the other thing, which I think is really key, is that what the similarities of GLBA and all these other regulations around cybersecurity, the things they're trying to really attack are kind of the administrative controls, the technical controls or physical controls in terms of how organizations handle data. And I think the reason why it's so different is because, you know, obviously they're in regulation or they're in legislation because they are, you know, legal things, but they're really hitting on the part that people aren't thinking about. So for me, I think about data as a, you know, it's kind of a technical or technological issue that has a legal ramification. It's not a legal issue that has technical ramifications. So if you're looking at it from the legal side of it, and you're not really looking at it from kind of the technical or data side, you're going to miss a lot of the nuance of what these bills and what these regulations are really trying to do. So they're really trying to make sure that organizations, in addition to, you know, I think earlier someone had mentioned, you know, companies are very good at figuring out what they need to do for their shareholders, but they need to think about people whose data they have as kind of stakeholders. So the stakeholders are gaining more traction within organizations because they have more legal protections.
Yeah, we're really seeing a big push towards the consumer, right? That is like, as much as, like I said, Europeans are complaining, but as much as they are, all of these laws are pointing to strengthening controls for the benefit of consumers. Claudia, what piques your interest in the GLBA changes from a USDS cybersecurity expert?
Yeah, and I'll date myself, but I go well before Sarbanes-Oxley, where I was flying around the world doing audits, and the idea has always been, oh, it has to do with compliance. What's the minimum that we can do? And I think the tide that is changing is tied, no pun intended, to the fact that we are looking at a situation where companies going forward, at least in the near future, are still going to say, well, we are doing the minimum because look at how the law is worded. You need to have this in place. You need to have that. Sure, we have a 3-line PIA, but at least it's a PIA because we put a PIA title on it. That's not going to work anymore. It's the technical aspects of things, and it's also the spirit of the law that needs to be taken into consideration. So I feel that data subjects are going to have the upper hand going forward. They're going to say, well, yeah, you went through all of these things, but they're meaningless. Unless you embrace the spirit of the law, you're not really compliant.
Yeah, and I believe that even like I put that limited exemption, because we're going to talk about exemptions and exceptions because they're also becoming very narrow. But the reason I put that there was to say that even for smaller companies, there's a lot more that is being asked of them because they're part of the ecosystem. So I just want to go to the Quebec Bill 64 and get Vanessa to get us started. What is new and what is directly intersecting with these cybersecurity changes, Vanessa?
Yes, definitely. And I think what you just mentioned is also very relevant because while GLBA, because I won't try to pronounce that one either, I'm very bad at it, but the GLBA
took me a few tries.
Yeah, no, but add the French accent to it. So the GLBA as a somewhat narrow scope, let's say, that goes around the financial industry. And that's a very US thing, right? We have the same thing going on with IPA, and we have the same thing going on with, these more sensitive data. So it's not true that there's no privacy legislation. It's just that there is on specific type of data. And that has left a very big gap for marketing. And that's where the issue came in. But if we look at this type of law, what they do in reality is they create a chain of contracts. And that's the thing that people don't see. And in my view, the contracts that are occurring between the company and the vendor due diligence that occurs because of this contract is actually doing a lot more than the legislator can ever do in terms of applying the law. So now if you want to work with an insurance company and you're an insurtech, you need to be up and running in terms of cybersecurity very, very high from day one. Yep. So now I have startups that are raising money for security purposes so they can get clients. So that has moved from compliance into sales. It's a sales issue. It's a business continuity issue. So that is a very different, it's a very different dynamics. And that's what we see in Quebec as well. The Commission d'accès à l'information, which is the regulator, has announced that they will be active, but obviously by the time that they put things in place, they do an inquiry and that we see the results, we still have a few years to go. But in terms of contracts, my clients are already pretty active and they have put changes and they have identified a service provider who do not comply with these new Canadian standard. And funny enough, often you go on the website and then they have the full GDPR compliance, but for Canadians, there's nothing. And I said, surely if you can give it in the European Union, you can give it in Canada, can you? Yeah. Okay, yes. So knowing your comparative law will allow you to get better contracts because if they can give it in one state, they should be able to give it in another state. And then the law becomes less relevant. I'm saying this because even if you're not in Quebec, if somebody's active in Canada, they can give all of this. They likely can give it to you in Ontario. That's the truth. So the law is one thing, and what you can get through contract, which we call private law, is what is very interesting that is coming out of this. So Quebec, the Bill 25 or the project, it was a Bill 64 was the project, has been adopted under the Law 25, actually is not a new law. It's an amendment to an existing law. many of the things that people talk about, for example, the liability of the director, it's been there for 30 years. It's just has never been used. The Commission d'accès à l'information is nowhere new, and it has actually published guidelines that nobody knows, but they're there. What the law does is that it now gives a lot more power to that regulator. These powers are very similar to what you would see with the Bureau of Competition. So it does include inquiry power, powers to give penalties, powers to actually act on its own. It does not need to go to court like the Office of the Privacy Commissioner at the federal level, which means that it's going to be a lot more efficient. And the big change is that the companies in Quebec will have to notify the incident. Now, it goes without saying, because you already have a principle in the civil code that says you need to be reasonable and you can be sued. So you do have to notify if you don't want to be sued. But now you have to notify the Commission d'accès, which can then make an inquiry. So that means that when you have an incident, you're opening the door wide open to other lawsuit.
Yeah.
Exactly. Yeah. And if you're in the consumer space, like consumer protection law applies to you, you cannot limit your liability. So here comes a class action lawsuit, and here comes the increase into the cost of insurance. So that really is the big impact of the Quebec Bill 64, because otherwise what it's adding in it, it's, for some people who've been following the law, it's a little bit of GDPR, a little bit of CCPA, a little bit of this, a little bit of that, with a Quebec twist on it. So let's say our right to data portability is slightly different, or the right to access the information now is a little bit broader. But down the line, the principles are the same across the world. What makes a law effective or not is, can you apply it? Last point I want to point out too is that this bill goes further than applying to personal information, because it now says when you should be authorized to anonymize them. And that's a big change. You need to have a legitimate and serious interest in doing so. So will that include marketing, and what will be the impact? It remains to be seen. We're waiting for the guidelines. There are many guidelines that will be issued in 2022 by the Commission d'accès à l'information. So this year will be the year where we get the guideline on each of these requirements. Now, I also see consent in your in your notes. There's consent, but there's now also exception to consents if you're processing based on a contract. So that is very welcome, because there's a consent fatigue out there that people are concerned about. And there's the clear clarification that lawyers were aware of, because it was in the jurisprudence, that an explicit and clear consent is required to process sensitive data. So there's no way you can use health data to do marketing unless you have a specific consent in written to say, yes, you can use my health data to do marketing. So this should be a very clear warning for societies and organizations.
Thank you, Vanessa. After I asked Peter to comment a little bit, and I'll give you a bit of context, Peter, I'm going to ask you all to think of 2 elements that you see intersecting throughout these laws. And I'm going to go through a rapid round of asking what your 2 elements are. So Peter, I want to come back to you, and I want to say we do see a lot of changes here from a privacy technology, privacy compliance tool perspective. What do you see? How are you prepared? What are your clients asking? What do they need in order to put their house in order?
Yeah, it's a good question. So I think, kind of taking a step back, a lot more customers we speak to are realizing how important privacy is to their customers. And this is kind of mentioned on the panel a bit already, but I think more and more companies are seeing privacy as that kind of differentiator for their companies. So I'm seeing more of a focus, particularly from the companies that have, look at their data personally as an asset to their company. But more and more so, companies are realizing they need to understand where this data is and what systems it's hosted on and where those systems reside. So really kind of what Opsware does well, shameless plug, is really focused on inventory of PI. You can't really, without a data inventory of your PII across your organization, it's kind of like going to the grocery store with a blindfold on. You're not going to be able to do it.
With no list. You're going to end up, either you're leaving with one item or you're going to buy the entire store. And you don't know why.
It's not just a list. Exactly. You need the context around it. Right. So I think, and really what I'm seeing as a driver for a lot of these companies, it really is the customer now. And that's an exciting shift we're seeing. Maybe it's just the folks who are speaking to are maybe a bit more advantageous, and they have, big goals of where they want to send their business. But that's certainly the biggest thing I'm seeing. But certainly, a starting point is a data protection impact assessment across your entire organization, right? And really to do that, you probably need a PII data inventory before or after that, depending on, or at least you're going to probably quickly discover that. So that's certainly the best place to start is where's the data, and really, because you can't protect it unless you know where it is.
Right. All right. So we're going through a rapid round of 2 elements that you see overlapping between all these cybersecurity laws and the Quebec Law 25. So between privacy and security, I'm going to start with Eeny, Meeny, Miny, Mo. Claudio, 2 elements. You're muted.
Well, there you go. You missed it. I just said it.
Okay, great.
So 2 elements that overlap between
all of these laws.
The 2. Well, the elements are incident management, which is obviously a growing aspect of things, and risk assessment. Yep. But there are so many others.
There's so many others. Debbie, what pops out for you? Okay, Vanessa, and I'll come back to Debbie.
I think, and I know it comes back all the way to the same thing, but it's a lot of organization. Whenever we come in a new business, whichever law they want to apply, half of the year is actually trying to understand what they do, why they're doing it, who are the third parties. And once we get that in place, the recommendations are always the same. You need to delete your data. You need to organize your data. You need to have new contracts.
Retention, classification, exactly. Peter, what stands out for you? I mean, you said data inventory, but if I was to ask you for 2 other elements, what would you say?
I mean, I think in general, it's just the principles, right? Like they both apply the same kind of principles behind them. That's the biggest theme and intersection I'm seeing between the 2 of them. And yeah, understanding your data across both of them and where it exists. Yep. And yeah, really where it exists and the context around that data. Yeah.
Understand the data in context and don't use more than you do because you don't understand it. And this is where I love where Law 25 is going with anonymization. I think I see a buzz in the privacy circles about anonymizing data, trying to get insights in such a way that you're not intruding into people's privacy.
And if I may, Amalia, yes, the reason why the bill is going that way is that most people do anonymization wrong to begin with. And the second thing is that anonymized data can be used for discrimination purposes. So maybe I cannot do interest-based advertising on you, but now I can say the entire town of Montreal is going to pay more than the town of Trois-Rivières, for example. So this is what we want to avoid. That doesn't mean that you cannot use data. You can use synthetic data because they're not anonymized data. So I think it's a call for innovation.
I totally agree with you. And I'm so glad you said that because this has been kind of one of those underlying currents we've been saying. All these changes and people are some companies are complaining there's so much, we have so much to do. No, it's about innovation. I am going to put it out there. It's about stop being lazy and start thinking outside the box how you can meet both your business objectives and privacy requirements, of course, security on top. Debbie, are you back? Can you give us the 2 elements that you think? Yes, please.
Sure. Well, one for me is kind of the rise of rights of the individual. So if companies don't make any changes whatsoever, their risk is going to increase exponentially because people's rights are rising. So it definitely has to be something that companies need to look at. And a couple other panelists touched on something that I like to talk about a lot, which is context. So this is where a lot of organizations get in trouble. Let's say they collect data for one purpose, but then they end up using it for another. That's definitely a slippery slope. And this is kind of what I feel like these laws are trying to stop, which is making sure people have a good reason that they can say, this is the data that I have, this is why I have it. And part of that is being able to figure out where your risks are in an organization, especially if you're reusing data and sending it to third parties and things like that. That may completely change the context for which the data was initially intended. And then also trying to comply with the spirit of the law, which is you shouldn't really be using people's data for things that they didn't agree to in the first place.
Right. I personally love this new amendment in the CPRA about telling customers, consumers upfront the retention of their data. I love that. I think that's brilliant. And there's so many of these elements that are coming from the US that are also, I also think they're kind of topping up a little bit GDPR. They're saying, wait, there's even more that we can do. So thank you so much for putting you on the spot and responding such a great variety of answers. I want to go, this is a slide from NIST. If anyone ever reads NIST standards, I do as my bedtime reading, as Debbie will start chuckling because she probably does the same. It is so, I think we have to go and explain over and over again that security is not privacy and privacy is not security. Let me just start kind of backwards. I'll take Vanessa first. How can you succinctly explain these differences? What is your take?
Right, and I think that comes back to the beginning of our conversation. Privacy is a human right. Confidential information is an economic right. When you're talking about violating human rights, we're not on the same level than we're talking about how to protect confidential information. So for example, in Canada, there's absolutely no law. There's no trade secret law. It doesn't work like that. You have to put your own cybersecurity. And if you don't, then you know what the court will tell you is like, how is that a secret? Right? So it is on you to be able to do that. So when we work with company and they say, we don't want to patent this, the answer is, okay, so how will you protect it? Because you can't print it, put it in a vault and then split it in 2 countries. You're working in a cloud native environment. So how do you protect it? When it comes to privacy, it's not a choice to begin with. It's an obligation from day one. And if you don't protect it, then there are consequences, not just on the businesses, but on the individuals for which you're liable. And these consequences can include punitive damages if you intentionally violate the human rights. So it's completely 2 different areas of laws, 2 things that are different. So it is important for companies to understand which is a personal data, which is a confidential data. And I know that the laws use the word confidentiality and then everybody's confused. Privacy is not confidentiality because it's also integrity and it's also availability, but it is only a subset of the data that you have. And it's a lot more, like you mentioned.
Yeah, yeah. Security is not privacy. Claudio, can you explain that for us?
Security can't be privacy. Security is an underlying set of limitations. So these are simply constraints. And if you put enough constraints together, you can actually layer on the ability to protect somebody's interests. Their human right to privacy, according to Article 12, has been around since 1948. And without having something dependable underneath that is nowadays enforced by technology, thankfully, without that, you do not have an enabler in place. So, so for example, privacy is often confused with confidentiality. I mean, there's just vast confusion out there as to, is there a difference? When I go into schools, I volunteer with the foundation and talk to kids, and I explain to them that privacy is their right to protect what they care about that's intimate and personal. The way that's done is using confidentiality controls, and I give them examples. We talk about scrambling data, we talk about putting long passphrases on things, and they get it. And of course, as Vanessa said again, confidentiality is one of the 3 objectives of information security. Of course, there are more if you look for them, but within the CIA triad, we obviously talk about confidentiality, integrity, availability, and these are made possible using actual underpinnings of effective controls like the ones that I mentioned, simple enough, passwords and encryption, but so many others, right? Everybody wants to talk about antivirus and firewalls and so on. That is the beginning of awareness. And that's what I like to see in the public. That's the kind of knowledge transfer that more of us should be doing.
So I usually say to people, it's not just about that I gave you access to information. It's about the fact that you now don't have carte blanche to go tell it to everyone and use it in every way you want, even maybe saying you've been doing those great things that somebody entrusted you and said in confidence. So Debbie, what is your take on this security versus privacy?
Can you hear me?
Yep.
Yeah. So I like to give the analogy. I try to tell people about, think about privacy and security as a bank. So the security, if you have a bank, there's security on the perimeter of the bank, is security inside the bank, right? Physical security. There's administrative controls. You want to but for me, privacy is sort of what's in the vault and why it's in there. So cybersecurity is not about why you have data. So when you're thinking about data in terms of privacy, as one of the speakers said, privacy would be is a right of an individual. And if you're handling data of individuals and you're not aligning it with the purpose, you're gonna be out of alignment with, some of these regulations. So it's about sort of why, what data you have and why you have it.
Yep.
And Amalia, I think the best example of what Debbie's talking about is surveillance. It doesn't matter if you protect my data, I want to be let alone, right?
Yes. Yep.
So these are two different things. And that's why we are having this situation between the US and the EU, because the US considers that as long as the government protects it, it's fine. The EU doesn't agree with that, right?
Mm-hmm. Mm-hmm. Yeah, very good perspective. Peter, if you go to a client and you say, well, you need privacy tools, and they say, no, we have security tools. I don't need any. What do you say?
I mean, like, kind of echo some similar thoughts here. Like privacy to, what I believe privacy is, it comes down to human right, but having choice and control as an individual or data subject is the most important thing. And that's really what companies need to focus on, and giving folks that control. I think you need security to have privacy. And the analogy I like to use and explain to companies is, think of security as having gates up on your windows, and privacy is really giving users control of their blinds. And that's kind of how I really kind of break it down to some folks. But certainly, I think they do intersect. Some companies do kind of have them all as one office, so to speak, which is pretty common. I'm a vendor, so I get a lot of questionnaires. I kind of have both of them, kind of have two questionnaires into one as well. So we see a lot of that. But certainly I think it's all about giving users control over their data. Yeah. And also understanding how you can use that data, right? And again, that's about them having, privacy in their own.
One of the things that I heard from the proposed SEC amendments is the fact, this whole idea of disclosure and telling an agency or a regulator that you've had a breach or you've had an incident and it's material. One of the differences is that we have to stop working in silos. So the IT department, the security department have to now float that information up to the legal department so they can actually understand how it impacts the applicable laws and what do they need to do to protect the organization, but also to protect the consumers for what that happened. So I think the reason we see all these changes is because we've been having these departments working in silos for so long. So let me move the conversation forward and ask you, what does it mean? What are all these laws that are starting to raise the bar, as we've seen? What do they mean for North American organizations in general, small, medium, and large? Claudio, what do you think? And I want you to talk about those exceptions. I think now is the right time to say, nobody's exempt.
Unfortunately, some organizations are exempt. So the GLBA's safeguards rule says that financial institutions that maintain the customer information of fewer than 5,000 consumers are going to be exempt from certain requirements. And those requirements are the obligation to conduct written risk assessments, as if you could conduct them in your mind, annual board reporting, because why report? Certain monitoring and testing requirements, and a written incident response plan. So it's a little bit disconcerting that these exist, because it begs the question, does the data of 1 to 5,000 people not matter as much as the data of others? In fact, in the cybersecurity world, we have ways of siloing things and reducing them to smaller pockets so that a breach or an incident won't access necessarily by default everything at the same time. You've got layers of security you can apply.
Yeah. This is why I love what Vanessa, I'm going to give you the microphone next. What Vanessa was saying, the contract between companies is what matters. We have these great standards. We have NIST standards. We have these great laws coming up saying more security, tighter controls, more oversight, accountability. But in the end, it's about how smart you are at putting a contract in place with your suppliers, right, Vanessa?
Right. I mean, I try not to do fear mongering about this privacy law. The reason is the number of companies who get cut are actually very, very small. And most of those who do get cut have a budget to pay for these fines. So it's not the fines who are actually going to change the industry.
That's
However,
right.
if we have somebody like a big banks that probably have 2,000, 3,000 supplier minimum, and they decide that they have minimal requirements to work with them and put that in their contract, now I have 3,000 companies who are compliant. And if each of these companies have 10 suppliers, then I have 300,000 companies that are compliant. So what we have seen has been I think the greatest impact of GDPR is the Article 28 that requires to have a contract with each of the supplier. And then because of this contract, there are audits that follows, and nothing hurts as much as losing a $10 million client. Now, look at the size of the companies that are on these. And it's not a lot, but if you look at the startup that is losing a $10 million contract, that's a business continuity issue.
Absolutely.
So I think the fines are there to move people into making these own verification that they should be doing on their own. So I don't think we should evaluate the success of privacy law based on the fines that are being issued, because there's a lot that's going on in the dark. And there's a lot of people who are concerned. And the same message goes about the liability of directors or officers or privacy officer. I have not seen that law being applied in 30 years, and I don't think it will be applied tomorrow. The obligation is to be reasonable. And that's a fairly easy obligation to meet, because that's your obligation on a day-to-day basis the moment you leave your house. If you willingly jump on somebody else and start hurting the person, you'll get sued. It's the same thing with the director and officer. It's not hard to meet that standard. You just have that big gap of things that you can do, and you just have to pick one that is slightly reasonable. So I don't think that we should do too much fear mongering around the fines, but I think companies should be very cautious that if they want to continue doing business with big organization, if they want to work with the government, if they want to be on the market,
fish. Yeah.
If they want to go public, if they want to do a merger and an acquisition, if they want to do pretty much anything, they'll have to have good controls, and very often above what the law contains.
That's right. Peter, what's your take? I mean, I want to thank you. This is your slide. You generously gave it to us for this presentation.
No, I think Vanessa hit the nail right on the head. Like, it's not even so much the fines, it's the implication of these and the reputational damage and risk that you take on that as well if it hits the press. And to that point as well, like, it's good business even to have these assurances in place from a privacy perspective to your customers. We work with a lot of, tech companies who are selling to very regulated companies, and we do it as well. We have it right embedded within our contracts that we have certain controls in place. We have certain assurances. We're obligated to audits from these regulated companies as well. So, that for us it's important for our sales cycles, right? It helps reduce our sales cycles, having these controls in place already, and being able to demonstrate that too. So I think that is totally ultimately what it comes to. And also it's good business, right? Like, we're seeing more and more reports coming out of consumers wanting more privacy, more control of their data. So ultimately, like, I'm just bringing it back to the user, back to the customer, which is good for, a lot of market people don't like privacy, but I think more and more realizing that privacy is a necessity and their customers actually want it.
Right. Debbie, your take.
Sorry, can you hear me?
Yep.
Yeah. I think, I am seeing a lot more being written into contracts in terms of companies making requirements, especially of their third parties, to be able to have a lot of these controls in place. And even though there just seems to be such a wave of kind of these regulations and requirements. I think companies need to really focus on the foundational principles of some of these things, and that will help them be able to more readily comply. So understanding that these regulations or these rules, they're trying to put reasonable measures in place, make sure that companies don't think of this as an afterthought. Companies that are signing contracts, they are trying to make sure that the third parties they're working with, they understand what their own obligations are. And then also just understanding that, you know, people have rights to understand what's happening with their data. Companies need to really hone in on the data that they collect. Maybe they're over collecting data, making sure having a handle on what they retain. A lot of times they're over retaining data. Some of those things will help companies really reduce their risk in these areas.
That's great. So kind of wrapping up here, because I know we only have a few minutes. I just put a few things on the slide. If our panelists want to add something, but for me, when I was thinking about this, improving overall everyone's ability to respect personal information of individuals and also protect their companies, it's about protecting the ecosystem. It's a little bit like what happened in the pandemic, but I'm not going to start that. It's about protecting others, protecting each other. We need to know that no organization is isolated, nor should consider a single set of standards, because in the SEC proposed amendments, they're talking about a risk assessment that fits with that company's profile, industry, what risks they think they are that are relevant to them. What are your company's plans for growth? Do you want to grow? Vanessa talked about mergers, acquisitions. Are you ready? You know, what kind of a report card you're going to present, you know? So if you're a vendor, fasten your seatbelt and you need to do more. One other thing, and I'm going to come back to the panel kind of for your last word, is the work is never done. And I've seen this throughout all of these regulations. There's a call for continuous risk management, as if it had to be said. Risk management is continuous. And this whole idea of putting the onus on the CEO or the boards, I mean, it's always been there, but now it's like, well, you got to have educated board members sitting on the board, so they understand what cybersecurity is, because they need to make good decisions. So I'm just going to go around the table, starting with Peter. What else do you see? What else would this mean for North American organizations?
I think a big thing, like, you know, and we're going through this ourselves, the offshore data. We're a small, nimble team, about 5 employees now, but starting early is always easiest, like as a small organization, because then there's less to work with, and really kind of, you know, your scope is a lot more limited, more so to speak, around what you have to manage, right? Like we have very few systems right now. We minimize our data collection, right? I mean, our most of our data collection is really on the marketing and sales side. Our product stuff's all within our customers' premises. But starting early, or at least just starting, is the biggest thing, I think, and focusing on it.
Okay, I have a great question that kind of fits into this. Someone in the audience asked, how are we reconciling the cultural differences between US, EU, Canada, and how it affects an organization's approach to privacy? Vanessa, what do you think?
I think there are culture difference, but I don't think that the principles that either the US, the EU, or Canada are trying to get to are completely different. I think down the line, everybody wants to protect privacy and wants to foster trust, because without trust, there's no market, which means there's no money, there's no economics, and everybody suffers. So there is an interest in building trustworthy relationship with consumers. We have seen consumers that are starting to be very wary of artificial intelligence. So how is Canada going to go through with their AI strategy if people don't want it anymore? Mm-hmm. So there is a need across the board, across all jurisdiction to agree on principles that work so that business can work. So I think there are cultural differences, but the principles are largely the same, from PIPEDA to Bill 64 to GDPR. The principles don't really change. Maybe the operationalization of this changed slightly. So for example, are you registered with this organization or the other one? But trust me, the difference between being caught with a bad cybersecurity or being caught with having data that you shouldn't have is very different than being caught because you forgot to register with an organization. So if you start a privacy program, start from the principle, put them in place, and then manage the exceptions one jurisdiction at a time.
And the cultural differences, the
Exactly.
nuances. Claudio, I really want to go next to you and address the same question, because I think cybersecurity has a little bit of an advantage. I'm not saying privacy doesn't, because we have the same principles, but we're also talking about human rights and different takes on that. But in cybersecurity, we have these great standards in the US and in Europe. We have ENISA. So how do we form a culture of security and privacy?
I think that's a great question. Our focus at MPC is to talk about practical privacy. And when I have these discussions with clients, I realize, and it's really weird, I realize it when I have these chats with clients, that it's almost unfair to say this client or that client or this entire sector doesn't care about some aspect of privacy. They're simply trying to prioritize things. And by prioritizing, we're talking about what's the threshold for putting a priority on certain remediation steps. So we've always looked at the real risk of significant harm. We've certainly talked about it recently in the context of PIPEDA. In the past, there's been discussions about what happens when there's a data breach and the data is encrypted. So, California's SB 1386 talks about various exemptions when the data is unavailable and the key is not lost. So I'm really excited about both the GLBA side, which ensures that every security event, not data breach, but event that touches information, even when it includes encrypted data, is still regulated under the law. And that's precisely because the FTC cares about not just confidentiality, but data integrity, which is my favorite of the three of the CIA triad. And in Canada, now companies are going, well, in Quebec, companies are going to have to keep a register or a registry of all events, of anything that's a confidentiality event or incident, regardless of its impact. Or, they're no longer having to say, well, in this scenario, I don't think it's going to impact these people.
That's right.
And that's a fantastic development.
And SEC does the same. It says, well, let us not stop at materiality. Let us know about everything so we can understand how bad it can become. Debbie, last kind of word to you. What do you see? You're from the US. What kind of cultural bridges can we build with our friends in the EU? Canada's kind of in the middle, which is really great.
I think in terms of cultural bridges, I agree that we need to be looking mostly towards the purpose of why we handle data.
Right.
And then understanding,
and
understanding that people have a right to see or right to know what's happening with their data. So I think getting companies more aligned on purpose will help them be able to comply with a lot of these regulations. Because almost all of them talk about purpose. They talk about context. They talk about aligning your business process with, what you told the consumer or individual that you're handling their data, and sort of being transparent. So knowing that all those principles exist or are articulated in all these laws will help companies better be able to comply.
Those were the famous last words. That was fantastic. Thank you so much, everyone. They were exactly the perfect words to end on. Thank you so much, the panelists and attendees. We will, of course, email you the link to the recording. And I hope everyone has a great rest of the week. Thanks again, and we'll see you soon. Bye.
Thanks, everybody. Bye-bye.